I have DPMG Prime versus Danielle Mayer and Roberto Martinez and all other occupants. This is 26-2201. Council, can I have your appearance?
Good morning, Your Honor. Norman Whitty appearing on behalf of the plaintiff DPMG Prime.
Okay, and then no one's appeared on behalf of Danielle Mayer or Roberto Martinez. You have submitted a default,
Correct, Your Honor.
and there was personal service.
Looks like we have service by attachment. Miss Mayer appeared at the first hearing. Mr. Martinez failed to appear.
The default judgment will enter. We'll get a copy of that in just a moment.
Thank you, Your Honor.
DPMG versus Tyler Banner, 26-02198. Appearance.
Good morning, Your Honor. Norman Whitty appearing on behalf of the plaintiff DPMG Prime. Elevator.
Okay, today was the date that was set for a hearing. This is for non-payment of rent. I do have a consent order for conditional dismissal for you, Mr. Banner. Says the matter will be dismissed today upon the condition that you pay past due rent, $1,441.16. The support cost, $212.94 for a total of $16.56.10. That's for your rent due period of May 31st, 2026, correct? It says the defendant shall pay $300 commencing May 31st and continue until the balance is paid. That's $300 a week.
Correct, Your Honor.
Okay. Until the balance is paid in full, payments will be applied first to the current monthly charges and then to the arrearage, correct?
Yes,
Okay, and that's your signature.
yes, ma'am.
You understand your right to be represented by an attorney?
Yes, ma'am.
You willing to waive that today? You also have the right to proceed to a trial where you get a demanded jury trial. You understand that? You want to waive that right? Does anyone threaten you to waive these rights? You have 3 business days to return to the court to request to set this aside if you later realize you misunderstood any of the rights that you've given up. Also, partial performance will not satisfy that. So if you don't do exactly what you say you're going to do, which is pay the $16.56 in increments of $300 a month, or you pay it all in advance. If you don't comply with that, they can request judgment to enter against you. You will not get a new notice for hearing. You understand that?
Yes, ma'am.
Do you have any questions at this time?
No, ma'am.
Any additional matters for the record, counsel?
Nothing further, Your Honor. Thank you.
We'll get you paperwork in just a moment.
Yes, ma'am.
No problem.
Well,
Did they resolve the hearing for Reese.
Yeah, yeah, he's still back to talking.
That's what's wrong.
Yep.
Oh, we don't do attorney abuse now.
Yeah. Keep your earshot.
That's what we.
I'm on her case.
S3 Fund versus Kathleen Price and John Price, 26-02164. Appearance, please.
Good morning, Your Honor. Alan Dyer appearing on behalf of the plaintiff P 54857.
And good afternoon, or good morning, Your Honor. Sierra Oliver, PA 7707 for the defendants.
Judge, the parties have reached the terms of a conditional dismissal, which I believe has been submitted to the court.
You can put the terms on the record.
I also do have a physical copy here too, if you would like.
You can put the terms on the record.
Absolutely.
Judge, the parties have agreed to a vacate date of on or before June 3rd. There is no monetary amount listed, and it is a 4B conditional dismissal.
Is that correct, counsel?
Yes, Your Honor.
Kathleen Price.
Yes, sir.
And is that how you want to proceed with the conditional dismissal?
Yes, sir.
And you want to give up your right to trial in order to do that?
Yes, sir.
And then you're John Price,
Yes, ma'am.
and that's how you want to proceed, sir?
Yes, ma'am.
And you want to give up your trial right?
Yes, ma'am.
Sign with both permissions. The defendants and you both understand that partial performance will not satisfy this agreement, so you must follow the agreement to vacate on or before the date that you agreed on. You understand that?
Yes, ma'am.
Otherwise, judgment can enter against you. You will not get notice of a new court. You understand that? Do you have any questions? You have 3 business days to return to the court. If once you leave here, you realize you misunderstood any of your rights, you can request to have this set aside, okay? I've signed it electronically. Any additional matters for the record?
Nothing further, Your Honor.
You're all set.
Nothing for
Thank you very
plaintiff.
much.
You're all set. Thank you.
Have a great day, all. Thank you.
You too. A 215 Westmorland Ave versus Kyra Jones and Iva Jones and Bianca Pierce, 26-02203. The council appearance, please.
Again, repeating, Don Keski for plaintiff. Also on Zoom is Kip Wilson from Renaissance Property Management, agent for the owner.
Anybody here for Kyra Jones?
I think they're in the hall. I know they
I don't know
said
if the Bianca was here. I don't know why anybody would be in the hallway for court.
Your Honor, we have submitted a conditional, consent order for conditional.
Sir, we don't
dismissal.
have anybody, we don't have anyone in the courtroom yet, so we can't proceed.
Okay. It was signed by counsel, Your Honor. I think Billy Dijon was going to be there. Dijon. In place of Counsel Ross.
I'm a court reporter in here, so I don't know why you're still talking. Counsel?
Your Honor, I'm filling in for Jessica Ross. She had a family emergency.
Appears for the record.
Billy DeShone, on behalf of Kyra Jones.
Okay, thank you. Okay, Mr. Kesky was indicating that there's been a conditional dismissal.
That's correct.
Conditional dismissal is only as to Kyra Jones.
That's correct, Your Honor.
What are you doing with the rest of the individuals? Are you dismissing against them?
Well, we can, but Your Honor, we believe the lead tenant will honor these terms, and it would become
It's not
moot
about-
again.
It's not about that. I cannot just enter a conditional dismissal. I have to do something with the rest of the people on there or the cases lingering. And the civil department's gonna contact me and say, Judge, what do you want to do with the rest of these people? And I'm gonna go ahead and dismiss them. So I'm asking you on the record if you want to dismiss them.
Well, we can send in dismissals, Your Honor.
Okay. Okay, so Bianca Pierce and Iva Jones will be dismissed. Who's Bianca? Okay, you can step back there. Okay, thank you. And then you are Kyra. Okay. Okay, so the conditional dismissal states that you will pay the past due rent 1403.57 plus court costs to 1504 for a total $1,618.64. That's for rent due through a period of May 31st, 2026, correct?
Yes.
It states the plaintiff agrees to a one-time fee adjustment of $425 reflected in 2A. Defendant shall pay $809.31 towards the arrearage to the plaintiff no later than the 25th of May, 2026. Defendant shall pay the remaining balance of $809.30 of arrears to plaintiff no later than June 25th, 2026. Defendant shall pay accruing monthly rent for June on time. As long as the defendant is in compliance with these conditions, no additional late fees shall accrue during this repayment period. That's accurate, ma'am?
Yes, Your Honor.
You understand that you have the right to proceed to trial?
Yes,
Okay, you could have demanded a jury trial. So you want to waive your right to trial in this matter?
yes, Your Honor.
Okay, is anyone forcing or threatening you to do that?
No.
You understand partial performance will not satisfy this, so you need to pay the amount due in 2D according to the terms that you agreed to, or you can pay it earlier than that. Otherwise, if you don't comply, the plaintiff can request judgment to enter against you and evict you without giving notice of a new hearing. You understand that?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
You have 3 business days to return to the court to request to set this aside if you later realize that you misunderstood the rights that you've given up. Do you understand that?
Yes, Your Honor.
I signed it electronically. Can someone give me a dismissal for the other 2 so I can give Ms. Bianca a copy? Thank you. Any additional matters for the record?
Your Honor.
Nothing further, Your Honor.
Thank you. You're all set.
Yep, thank you.
You're welcome. Thank you.
Okay.
JDO Ventures LLC versus Joshua Smith, 26-02209.
Good morning, Sam Joy here on behalf of the plaintiff.
That's all I see is Oliver Communications. That's Joshua.
She has the date.
Thank you.
Terrence,
Thank you, Sam Joy here on behalf of the plaintiff.
Hey, good morning, Your Honor. Sierra Oliver, P87707 for the defendant.
okay, this was a hearing for non-payment of rent. Have you all resolved this?
Yes, we have entered into a consent order for conditional dismissal, if I may approach.
Yes. Okay, so it will be dismissed upon the condition that the defendant vacates by the 30th of this month, correct?
Yes, Your Honor.
Okay, that's correct, sir? Okay, you understand that you have the right in this matter to proceed to trial?
Yes.
And you have the right to have a jury trial. You understand that?
Yes.
You want to waive that right?
Yeah.
Okay, no one's threatening you to do that, correct?
No.
Okay, let's see, partial performance of this or partial payment of any past due rent will not satisfy this agreement, and you have 3 business days to return to the court to request to have that set aside if you realize you misunderstood any of the rights that you waived. Do you have any questions at this time? We'll get you a copy of paperwork in just a moment. Any additional matters for the record?
Nothing, Madam Judge.
And nothing further. Thank you.
You're all set. Thank you. Capital Commons versus Steve Reese, is the attorney still? He might not be available.
Oh. She called Florida. She went to Florida. And she's, we have 2 choices. We can come back next week. Or 17 days instead of 10 days. You know, 10 days you would get.
Interesting.
You can get those issues, I think, an hour and 15 minutes.
Capital Commons Senior versus Steve Reese, 26-02189, appearance, please.
Good morning, Your Honor. For the record, Ronnie Dad for the plaintiff.
Name, sir?
Steve Reese.
Okay, Mr. Reese was scheduled today. This is for a hearing for termination of tenancy. I do have a consent judgment here. It says that you're consenting to judgment against you where the plaintiff will have the right to retain or recover possession of the property, and you will vacate no later than June 19th, 2026, correct? Okay. And you understood that you had the right in this matter to be represented by an attorney?
Yeah.
You want to waive that right?
No.
You want an attorney?
What's that?
You understood you had the right to be represented by an attorney in the eviction? She doesn't represent you. She represents Capital Commons.
Okay, well, we're talking now, we're talking the case or
Excuse me?
what case you talking about?
I'm talking about your eviction.
Yes.
She does not represent you. She represents the landlord.
Okay, okay.
I'm asking you, did you understand that you
Yeah.
had the right to have an attorney represent you?
Oh, Okay,
You understand that?
okay, yeah.
And did you want to waive your right to represent yourself in the eviction?
I don't know what I signed.
You don't know what you signed?
I know what I signed, I mean, we were talking about. Yeah, that's. what I
Yeah, but
signed.
but did you understand my question?
Ma'am, you gotta say. I don't.
You can have a
quite-
seat.
All right, I don't quite understand, all right? But I just trying to know, I'm going by what I signed.
Yes, but I'm trying to now determine if you understood what you signed, if you
Yeah, yeah,
understood
yeah.
that by signing this, you have to waive rights.
Okay,
So your first right is your right to have an attorney represent you in an eviction matter. You understand that?
okay, I know.
I didn't ask you if you have.
Oh,
Are you going to waive your right to an attorney so that you can proceed with this?
yes.
Okay. You also have the right to proceed to a trial in this matter. You understand that?
Okay.
Did you want to have a trial or did you want to do this?
I wouldn't do that.
So you want to waive the trial. No one's forcing you to do this agreement, correct?
No.
No one's promising you anything if you waive your rights?
No.
Okay, and that's your signature at the bottom of this page?
Yeah.
Okay, and so we have 3 business days from today to come back to the court. We're closed on Monday, so you have until Tuesday of next week to come back to the court. If you leave here and you said, I don't understand the rights I've waived, you can request to have this set aside. You understand that? Do you have any questions about this? Okay, I'm going to give you a copy of that paperwork. I've signed it. Any additional matters on that record?
Nothing further, Your Honor. Thank you.
You're all set, sir. And then this is not on that matter, that is, you have a contempt report. This is now the state of Michigan versus Steve Reese, 25-01663, council appearances.
Thank you, Your Honor. May I please support Assistant Prosecuting Attorney Dan Smith here on behalf of the people of the state of Michigan.
Assistant Public Defender Jessica Straub on behalf of Mr. Steve Reese, who is in the courtroom, but I am remote.
Okay, today was the date that was scheduled for a bond violation, PA 53. How are we proceeding?
Your Honor, it is my understanding that Mr. Reese is going to plead guilty today and accept responsibility.
That's correct, Mr. Reese? Use your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Okay. You understand your right to have a contested hearing on the violation? Okay, and do you want to have that hearing or waive your hearing?
Yes, good.
Excuse me?
Yes,
Yes, what?
yes, what is the question?
Do you want to have a contested hearing on the violation, or did you want to waive your hearing and plead guilty?
Nothing, just,
Okay, is anyone threatening you to do that?
no.
Okay. As to the violation from July 13, 2025, alleging that you appeared in the protected party's presence and had in your possession multiple knives in violation of your bond conditions prohibiting dangerous weapons. How do you plead?
Not guilty, it was kitchen knife, it was gift. It was gift to my welcome out to my new home.
Oh, not guilty?
Not guilty on that, you said knives. That was a house gift when I moved in my first apartment.
I have no idea. I'm just asking you how you plead. He says not guilty, so we gotta have a hearing.
Okay, Your Honor, can I have the PA 53 violation that you're talking about? The one that I had did not have those details in it.
What bond violation are you talking about?
The one I have says something about picking him up from Sparrow and transporting him.
That's not in my file.
Yeah, it's very brief. It does not have that substantive information in it.
We see what he sent you, what she said, I mean, what was sent to you, it's the same thing I just read.
That's not,
With the first page,
here, let me take another look.
that's not, unless that's on the wrong file, it says Steve Reese, violation, 7/13, 12, 36 hours. Defendant violated those conditions as follows. Appeared in the protected party's presence and had in his possession multiple knives in violation of the PA 53 condition prohibiting dangerous weapons. He stated to officers that he would cut off their legs with weapons he had in their possession. That's on the very first page of the actual thing that says complaint for violation. Did you read that part?
I did not, Your Honor. I missed that part. I read the narrative part. I do have that now and I do see it.
The
How we
officer is right there, so if he wants to contest the hearing,
We have the officer in the courtroom that was allegedly threatened to have his legs cut off with the gifts for the, we already had him admit on record that he had the knives. So now we just gotta move forward with whether or not he threatened with the knives. And allegedly, these knives were at Sparrow. That. Do you need more time to counsel your client?
That very well may be, Your Honor.
Okay, off the record, you can go back and talk to your attorney because she thought you were pleading to the charge. You're not pleading to the charge. So you can go talk to her about how you want to proceed. If you're gonna have a hearing, she's gonna possibly have to come over here. I don't know, but that's up to you all. see here. Patrick Kums versus Brandon Kebler and all other occupants, 26-02228.
Good morning, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Patrick Kums. Mr. Kums is also present.
Hi, Mr. Kums.
Hello, how are you?
I'm doing all right. How are you?
Connor, nice to see you again.
Good to see you too. Okay, let's see. Mr. Whitty is representing you on this. Did Mr. Kebler appear?
No, and I've called for him in the hallway.
Judgment to enter.
Thank you.
Get your copy in just a moment.
Appreciate it very much.
Thank you. Nice to see Mr. Coombs represent himself. That's all. Marketplace Partners versus McFerson and all other occupants, 26-02244. Appearance, please.
Good morning, Your Honor. Jeff Landon, P 74077 on behalf of the plaintiff.
Your name?
Nadia McPherson.
Okay, McPherson is here today. This is for a hearing for non-payment of rent. It says here, their matter will be dismissed upon the condition that you pay the past due amount, $3,528 plus court costs, $173.22. It says other money due. What is that?
Primarily utilities. Your Honor. I have a breakdown.
You're not disputing that, correct? Okay, sure. For a total amount of $4,392.12, correct? That's for rent due plus other monies through the end of May 2026, correct?
Yes.
Okay, it says defendant shall pay $500 a week beginning the 28th of May, and each Thursday thereafter, payments shall be applied to the current month's rent plus utilities beginning June 2026, and any excess shall then be applied to the back rent item amount in 2D. If current monthly rent beginning June 2026 is not paid by due date, late fees will apply. Is that accurate?
Yes.
Okay, you understand that you have the right to have an attorney represent you, and you want to waive that right? You also have the right in this matter to proceed to trial or jury trial, and at that time, present any defenses to why you didn't pay the rent. You understand that? You want to waive your right to have a trial?
Yes, sure.
And that's your signature, correct?
Yeah.
Okay. You have 3 business days to return to the court. If once you leave here, you realize you misunderstood your rights, you can request to have this set aside, and then we'll set up for a hearing for you to explain how you misunderstood your rights, okay?
Yes, sure.
Lastly, partial performance or partial payment, section 7 says it will not satisfy this agreement. So if you don't comply with what you said you're going to do, making the payments and the amount due on the dates that you say you're going to pay them, the plaintiff can request to have you evicted. You will not get a new court date. You understand that?
Yes, sure.
You have any questions for the court?
No, Your Honor.
Any additional matters for the record?
Nothing, Your Honor.
We'll get you a copy in just a moment.
Thank you, Your Honor.
No problem. I will help. Here. Anybody else is here on the, let's see, Ms. Pereira is here. Capitol Village versus Chris Chalfant, 26-02235. Appearance, please.
Your Honor, Adam Devlin, P 72877 for the plaintiff.
And good morning, Your Honor. Veronica Pereira on behalf of the tenant, Chris Chalfant.
Chris Chalfant?
And Chris Chalfant.
Very good. Okay, today was the date that was scheduled. This is for a hearing for non-payment of rent. How are we proceeding, counsel?
Your Honor, we submitted the conditional dismissal to the court for execution.
Can you place the terms on the record?
Your Honor, rent to retain is $3,393 through the end of May, $171.53 in costs. Total is $3,564.53. Defendant will pay the total in paragraph 2D as follows: $1,750 by May 31st, $1814.53 by June 30th, and they'll also make June's rent payment by the 5th of June. If any payments missing or incomplete, plaintiff may proceed pursuant to paragraph 4B.
That's correct, Ms. Pereira.
Yes, Your Honor.
Ms. Chalfant, that's accurate as to your understanding is how you want to proceed?
Yes.
Oh, okay. You understand that you would have to give up your right to have a trial in this matter. That would include a trial by jury. No one's threatening you to give that right up, correct? The partial performance or partial payment of the amount in section 2 and the payment plan in section 3 will not satisfy. You have to comply completely. Do you understand that?
I do. Yes.
Otherwise, if you don't, they can enter judgment against you. You won't get a new court date if they do that, okay?
Yes.
You have 3 business days to return to the court. If you later realize you misunderstood the rights that you waived, you can request to have this set aside, okay?
Yes.
Do you have any questions at this time?
I do not.
Any additional matters for the record, counsel?
No, Your Honor.
No, thank you, Your Honor.
Thank you. You're all set.
Thank you so much.
You're welcome.
Thank you.
Thank you. Let's see here. Let's just see here. Capitol Village versus Robert Williams, 26-02243.
Your Honor, Adam Devlin, P 72877 for the plaintiff.
Who's Robert Williams?
Robert Williams.
Counsel appearance?
Billy DeShawn, on behalf of Mr. Williams.
Thank you. Okay, today was scheduled for a hearing. This is for non-payment of rent. And my understanding is there has been a resolution on this.
Yes, Your Honor. Conditional dismissal has been entered for this case already for your signature and review. Converted to a termination, defendant shall vacate on or before the 19th of June, or we may proceed pursuant to 4B.
Okay, is that accurate, counsel?
Yes, Your Honor.
Okay, and then Mr. Williams, that's accurate?
Yes.
Okay, so the case will be dismissed and you'll vacate the premise order before June 19th. That includes leaving the property in broom truck condition. Do you understand that, sir? You understand that you had the right to proceed to a trial in this matter and you could have had a jury trial? You want to waive that right, sir? You want a jury trial?
No.
Okay.
I'm sorry.
So you want to waive that right? Okay, no one's forcing you to do that, correct? You have 3 business days to return to the court, request to have this agreement set aside. If you later realize I misunderstood the right that I've just given up, you can request a hearing to explain how you misunderstood your rights, okay? Any additional matters for the record, counsel?
No, Your Honor.
You're all set, thank you.
Thank you.
I don't know what happened to Ms. Straub. Is she coming over here?
Reese said she told me she was.
Was Martin taken care of? Because he's not on my docket. Birch tree, I think that was this. Oh. So she's coming over here. Got it. come forward. That's on the record. State of Michigan versus Steve Reese. And then Ms. Travis is here in person at this time. How are we proceeding on the violation?
It is my understanding, Your Honor, that Mr. Reese would like to proceed with the contested hearing.
Okay. You can have a seat.
Sorry.
Sorry, witness.
People call Officer Howard.
You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, Your Honor.
You can have a seat. And then if you can state your first and last name and then spell both.
Peter Howard, PeterHoward.
You can proceed.
Thank you, Your Honor. Officer Howard, are you currently employed?
Yes,
Where are you employed?
with the Lansing Police Department.
And what are your assignment at the Lansing Police Department?
General patrol as a police officer,
How long have you been in this assignment?
approximately 12 years.
12 years, okay. Were you on duty on July 13th of 2025?
I was.
Okay, and did you on that day encounter someone that you see present in courtroom today?
I did.
Can you point that individual out and identify him by an article of clothing?
Yep, it's the gentleman over here with the blue sweater with the tan on it.
Your Honor, may the record reflect the witness has identified the defendant?
Any objection? No. Identification study.
Officer Howard, tell us what was the initial call that brought you into contact with the defendant?
It was a PPO or a PA 53 violation.
Tell us what happened when you arrived in response to that call.
I spoke to the protected party of a PA 53. I believe her name was Miss London Spurs.
What happened after you spoke with the protected individual?
I spoke with her and determined there's been a violation. And then I went inside the Advent House at 743 North Martin Luther King and made contact with the defendant.
What happened when you made contact with the defendant?
He was loud, boisterous, very upset. We eventually took him into custody for the violation of the protected order people.
And when you took him into custody, what was his demeanor?
He was argumentative, uncooperative, very loud and upset, threatening.
What happened when you were taking him into custody?
He was screaming loud things, threatening to cut our legs off.
Did he have any weapons on him at that time?
In some bags, we found them later at the jail when we were searching his property, several knives.
Describe those knives.
I don't recall exactly who tagged them in the property, but they were large kitchen knives, from what I recall.
And you said that he made active threats towards you?
Correct.
Can you repeat again what exactly he said?
Threatened to cut our legs off, officer's legs off.
Were you with an additional officer?
I was.
He threatened that officer as well?
We were both standing there together, so I took it as a threat. I don't speak for him, but we were both standing there.
And how did this incident conclude?
He was taken into custody downtown at the jail, and I believe he was taken to Sparrow Hospital for a mental health evaluation. However, I was not involved in that part of it.
Did you check to see his bond status at that time?
I did.
And what was that?
He was out on bond. He had a PA 53 protecting both parties.
Okay, no further questions.
Officer Howard, you mentioned that you responded to a PA 53 call on the behalf of Ms. Fundenberg.
Yes.
When you arrived there, where did you find my client?
He was downstairs in the 743 North Michigan cafeteria coming out of the back.
Okay, so you actually witnessed him coming out of the back and you were inside.
Correct.
And at what point did you begin to interact with him?
When we went into the basement of the cafeteria when he came out of the bathroom. I believe we talked to staff and asked him if he was there. and then he came out of the bathroom. I believe they indicated that's what it was, so we waited.
Okay. Did you ever ascertain whether or not he was at that location first, or whether Ms. Fundenbunks was there first?
I would have to refer to my report. I believe she was there first, so I refer to the report.
Okay. I actually don't have a report. Do we have a report?
A report from the PA 53?
Yes. Narrative that was described. I don't think it's on there either. So if I were to hand you a report, the report from that day, it would refresh your memory.
Yes,
Your Honor, permission to approach.
Yes.
my narrative is in there. It will be- Not my report. This is a supplemental report, but my part of it is not included.
Okay, so you can't recall whether or not Ms. Fundenbunks was there first, or my client was there first?
Correct.
Okay. What is Abbott House?
It's like I wouldn't call it a day shelter, but they provide meals and other activities for people that need it.
Okay, sort of like a drop-in location for homeless people.
Yeah.
Okay. Would it have made a difference if he had been there first?
No,
Okay, so he was not allowed to be at that location at all?
no, he was allowed to be there. Yeah. However, if she appears there, he has to be based on the order.
Okay, and how were you made aware that he knew she was there?
She testified, or she told me that she was sitting at the table in the cafeteria and he approached her and sat down at the table next to her.
Okay. And you also mentioned that he had knives in his possession. Were they on his person?
They were in, I believe they're in some bags, and then his walker had a bunch of property in it too, and they were all kind of sorted throughout all that.
Okay.
If I recall.
And those items kind of presented like a homeless or houseless person's belongings that they carry with them all the time.
It's, yeah, just typical of that, yeah.
Okay, so it'd be reasonable to not assume that he was carrying them around as weapons to hurt Ms. Fundenbunks.
I wouldn't say that.
Okay. Would you say that he actually removed any of those knives and physically threatened her with them?
No, there was no indication that happened.
So you never saw a knife on his person?
In his property, but not physically in his hand.
Okay. So when he was yelling things at you, he wasn't doing that in a way that posed an imminent threat that he was actually going to cut anyone?
No.
All right. No further questions.
Any redirect?
I know redirect.
Thank you, Officer Howard. Any additional witnesses?
No,
Any witnesses from the defense? Argument.
Your Honor, I believe you've heard the testimony. Testimony stated that Officer Howard got a call about a PA 53 violation, that the defendant came into this location where the protected party was already at. He sat down next to the protected party. He knew that he wasn't supposed to be there, and if he saw her, he wasn't supposed to be within 2,000 feet. He should have turned around and left. After he was approached by officers, he threatened officers. He had multiple knives on him. They were in around his person, so he did have the ability to take out those knives and use those. So in addition to in addition to being around the protected party, he also engaged in some assaultive behavior, and he had knives on him that could pose a danger. So, Your Honor, I ask that you find the defendant guilty. Thank you.
Sure.
Yes, Your Honor. We did hear testimony from the officer today that he was indeed at a location that the no contact or complaining witness was also located at, but it is not clear whether or not he was at that location first.
And how does that matter?
Well, it does appear to be a drop-in shelter, Your Honor. And I'm not sure whether or not Mr. Reese really registered that that was Ms. Fundenbunk's. It is not clear whether or not he went there to seek her out. No testimony today has mentioned that or asserted that. It is also clear that those knives that were mentioned were not on his physical person, but rather in his belongings. And as a person without housing, it could very reasonably been that he just carried those around for various purposes, for living purposes and not for any threatening purposes. As he did not physically threaten with those knives, the actual police or the complaining witness, Your Honor, we would ask this court to not consider this a violation of his bond.
I would just say that he had an ample opportunity, once he did find out this was a protected party, to leave. He did not. Your Honor, asked you guys were guilty. Thank you.
The court order was for him not to be anywhere where the defendant or the protected party was. Not, it doesn't matter if she's there first. And then now the allegations or the testimony is not only was he where she was, but went and took it upon himself to sit directly in front of her. Do I think that there was a situation where it didn't register to him that this was the person that he is being accused to have assaulted on a previous date and time? I think it did register. Mr. Reese is far more astute than that he knows who's in front of him and who's not. And so the violation today is not just that he was in the presence of the protected party, because if I was here with just an allegation that he showed up to the Advent House or to the drop-in shelter and it just so happened that the other party was there, we wouldn't be here. I've had that happen in multiple times. We wouldn't be here. I'm not holding you in contempt for that. The contemptible behavior became when the police tried to come and engage as a result of the 911 call and his behavior from that, because he also has a bond condition and he's not supposed to have any dangerous weapons, and he's also not supposed to engage in any assaultive or threatening behavior. Would telling officers that you're going to chop their legs off be threatening behavior?
Yes, sir.
Then we have a violation. Also threatening behavior would be when you come off the elevator at the court, you brandish your colostomy bag as if you're going to throw it at somebody so you can let people know that it's full. Try throwing a bag in here today and see what happens. You did that the last time you were remanded. I guarantee you, I will light you up for every single violation and you will serve a full year in the jail. Do you understand me? You have more control over your behavior than you like to pretend when you come around courtrooms. You want to come in here, you want to yell at people, you want to yell at your attorney, you want to curse out lawyers, you want to act like you don't know how to behave when you're already here for 2 counts of assault and battery. Using your walker to try to now create a picture that, oh, I didn't know what I was doing, I have all these medical concerns. These medical concerns aren't stopping you from assaulting people. If you're so sick, then focus on your illness and stop assaulting people, or you'll be sitting in jail. Do you understand that? So I'm sustaining the violation from July 13, 2025 as a contempt of court violation. Now, my understanding is he took a plea on this matter. He was sentenced to serve 30 days in jail. I gave him credit for 18 days. At which time, when he was being remanded, he ripped his colostomy bag out and started throwing it in open court. He was kicking, fighting, biting, and spitting court security while being remanded. I have that set for a contempt order on October 27th. Of course, he did not appear. That's direct contempt. We don't have to hold a hearing for that. I was present. Then I find out that the police release you from custody of the jail, likely because your behavior or possibly a medical condition. I don't know. I'm not going to punish and penalize security or police by putting you in their presence today. That's why these people are in here with gloves, because you don't know how to act. I got 4 fully able, well-bodied and armed security in here because of you. Sounds ridiculous. And you gotta have a caretaker bring you to court. I believe that this will resolve the matter. I'm not going to remand him today because I don't want to have to deal with the repercussions of his inability to control himself and his bodily fluids that are attached to his body. You need to focus in on your health and your wellness and mental wellness, okay? Because it doesn't sound like the way you're taking care of yourself, you have many days on this earth. You probably want to start treating people better. Do you understand that? You're all set. Thank you.
Thank you.
You're welcome. Riverfront Apartments versus Sonia Beechnar, 26-02-550, appearance, please. I just called the case.
Okay, yes, sorry, Judge. I was told by the defendant that she was waiting for her attorney, so I did not proceed to talk to her, so I'm not sure. I don't know.
Nobody, she told me that they called me for a court-appointed attorney. I talked to her, and that was it.
Court-appointed attorney, we don't have court-appointed attorneys. So
Okay.
legal services, you would have done a intake with them. If they were going to represent you, that they would have filed an appearance. You've not heard from them?
Nope. Okay, then if I pass, I can speak to her. My client's outside, so we'll try to. Thank you, Judge. I'm willing.
Victor Quack versus Alex Schmale, 26-02-666. Parents, please.
Shown on behalf of the defendant, Your Honor.
And that's going to be the big decision on the merits of the case.
Is there some background going on here?
That's me, Your Honor. I apologize. I'm in Judge Flores' room.
Proceed with option
Why you can't be in 2 courts at the same time?
I'm figuring that out as we speak right now. I apologize, Your Honor.
Okay, how are we proceeding on this matter?
Your Honor, it's my understanding that Attorney Ross and the opposing counsel filed a stipulation to adjourn, just to give the defendant some time to wait for a rental assistance application to see what's going to happen with that.
Is that correct, counsel?
That's correct, Your Honor. We did stipulate to adjourn this meeting, so his DC 539 form or his application can process.
Okay, I do see a step to adjourn that was filed last night at 8:30. I'll sign that and this matter will be reset.
Thank you, Your Honor.
Thank you. June 17th at 8:30. June 17th at 8:30. Did you get that date?
Yes, Your Honor, thank you.
Let's see. We have. Is Samantha McIntyre on there? Madam?
I'm right here.
Oh,
We
okay.
worked together, we filed together, so I'm not sure how that went.
But they're not representing both of you all, is that accurate?
I don't understand.
I'm looking into that,
Okay.
Your Honor, I'm sorry. Your Honor, I don't think that we had put an appearance. I don't think that Ms. Ross had put an appearance in for the other defendant, but looking at the notes and having spoken with her, I think I can verbally do so and we
Okay,
will
so you
represent her.
So both of them should have been reset, so. Thank you. You're all set.
Thank you.
This is Hamilton Road versus Elvis Saunders and Sylvia Heredia, 26-02683. Parents, please.
Gene Kernwald on behalf of Hamilton Road Limited.
Your name, ma'am?
Very good.
Your name, sir?
Elvis Saunders.
Today was the date that was scheduled for hearing. This is for non-payment of rent. How we proceed?
Your Honor, a short discussion with the defendants in the hallway. It's my understanding they're going to ask for an adjournment. We made an application for rental assistance and they assured me that it's going to be approved. The long-term tenants, I believe, they have no documentation.
You don't have proof of the application?
I have to pick it up today at 12 o'clock.
You have to pick up proof of the application?
SCR form, because it was an emergency one, so, when I sent the eviction copy of the eviction letter, they first had told me that to apply for the SCR, but then they said I needed a copy of that, so I had to send it in and then wait for their approval, which they did approve it. I just don't know how much until they give me that SCR approval paper to pay whatever other co-pays that we did.
But you were here for the pre-trial. We said that if you want an adjournment or you want your case stalled for assistance, you have to file proof within 5 days.
Yeah, that was at the time where we were both on the phone, on via Zoom, and the phone had somehow, disconnected, and I kept trying to, we were muting the one, what happened was somehow it both. But, yeah.
Yeah, you couldn't unmute or something to that effect. The other concern I have is, why are you wearing a bonnet in court?
I have hair thinning loss and I have like micro beads in my hair. I can take it off and show you.
Well, I'm just asking you about how you want to present yourself in public.
Oh.
And typically, you shouldn't want to wear your inside pajama clothes outside.
Yeah. Well, I don't have pajama on.
Well, your bonnet is for bed. It's when you're home.
Because I have some.
It's like wearing a bathrobe.
Yeah.
Okay, so you're gonna bring proof of a promise to pay?
Yep.
Okay, and when are you gonna do that?
I picked that up today at the DHS at 12.
At 12 o'clock?
Yep.
Okay, and so, but you don't know when the payment's gonna be made, just proof of promise to pay?
Yeah, it's just, well, they have to, I have to wait and see how, well, it's gonna get paid. He knows that we'll pay it. We just have to wait for how much they're gonna approved.
So you don't know how much they're gonna pay?
No, that's what the SCR form, the paper is for.
Can do the June 17th date at 8:30. June 17th at 8:30. I will get you a notice, and you need to still follow your proof of promise of pay, okay?
Okay,
Yeah,
I'm sorry about the hair bonnet too as well.
Well, it's really just for you, just how you present yourself in public.
Well, I mean, it wasn't intentionally to present, like I said,
All right, I'm recognizing that you have some reasons why you wanted to cover your head. But what I'm saying is there's other ways that you can do that, okay? Any additional matters for the record?
No, Your Honor.
We'll get you a notice to appear, okay? Thank you.
Thank you, Your Honor.
Did we see Gibson? Oh, I guess for earlier. Okay, this is Riverfront Apartments versus Sonia Beach 9, all the occupants 26-0255 LT, appearance, please.
Yes, Rania Haddad for the plaintiff.
Your name, ma'am?
Sonia Beach now.
Okay, you can stand there. Today was the date that was scheduled for hearing. This is for eviction for hazardous conditions or injury. The parties have executed a consent judgment whereby you would vacate the property no later than June 19th. Is that correct?
Yes.
Okay. And you understand that you have the right to have an attorney represent you?
Yes, ma'am.
You want to waive that right?
Yes, ma'am.
You also have the right to proceed to trial. You could have demanded a jury trial. Do you understand that?
Yes, ma'am.
And you wish to waive that right?
Yes, ma'am.
Anyone threatening you to waive these rights? Who's threatening you?
I mean, no, nobody, I'm sorry.
Okay. Okay, you have 3 business days to return to the court. If once you leave here, you realize you misunderstood these rights, you can request to have this set aside and explain how you misunderstood your rights, okay?
Yes.
We'll get you a copy of the paperwork, any additional matters for the record.
Nothing.
You all set? We've seen Marla Gibson. We're the plaintiffs.
Marla Gibson.
Attorney.
Marla Gibson.
Who's here for Freeman?
Oh,
No, no Marla Gibson
no,
and no attorney for Freeman?
are you? No, I don't see attorney.
No, that's not good. You can have a you can stand up. Evan, actually.
Oh.
This is the matter of Woodbridge Apartments versus Marla Gibson and all other occupants 26-02688. Appearance, please.
Good afternoon, or morning. Your Honor, Ronald Bach here for the plaintiff.
And you are Marla Gibson. Okay, so I have a consent order for conditional dismissal. It says the matter will be dismissed today upon the condition that you pay the past due rent of $3,193.63 plus $176.54 in cost for a total of $3,370.17, correct?
Yes.
This is that's for rent due through a period of June 30th. Defendant shall pay $700 each week, starting 5/22/2026 until her balance is zero and current. I'm sorry, when is her rent due?
First, I believe it's first.
The first of the month? Where are we talking about June 30th rent? I don't do conditional dismissals on advanced dates. Why is this rent? She's
Well,
not
we
past
added
due.
June rent in because the payment goes through June 30. And then
So by
the end
June
of
30th, you're saying she'll be paid in full
she'll be paid in full by the 19th.
of June?
Yes. If we do it like that.
How much is her monthly rent?
I believe it's 1040, Judge.
That's your monthly rent? You understand that you have the right to have an attorney represent you today? You want to waive that right? You also have the right to proceed to trial. You could have demanded a jury trial. You understand that?
Yes.
You want to waive that?
Yes.
We want promising you or threatening you to do that? You have 3 business days to return to the court. If once you leave here, you realize you misunderstood your rights, you can request to have this set aside. A partial payment will not satisfy this agreement. So you got to pay what you say you're going to pay on the dates and times you say you were going to pay them. Otherwise, judgment can enter against you. And you won't get a new court date. You understand that? Yeah. That's your signature.
Yes.
Do you have any questions?
No.
Any additional matters for the record?
No, Your Honor.
I will get your paperwork in just a moment.
Thank you, Judge.
Thank you.